Welcome to lecture number 10, The Privacy of Cell Phones and Cell Phone Records. 90% of U.S. adults have a cell phone, and more than half of the phones are Internet-enabled. Today's cell phones do much more than simply make telephone calls, and are devices that store photos, financial information, and other personal information, as well as allow access to the Internet. Data on a cell phone can reveal not only who someone has communicated with, but also reveal an owner's search history, historic location information, and a wealth of other information about him or her and with whom they associate. For years, there was a split in judicial authority on whether law enforcement needed a warrant to search one's cell phone when the phone is seized incident to a lawful arrest, which is a long-recognized exception to the necessity of a warrant. In Riley v. California, a unanimous U.S. Supreme Court held that a warrant is required, noting that cell phones are essentially mini-computers that contain or allow access to vast quantities of personal information. The court noted that modern cell phones function as cameras, video players, Rolodexes, calendars, tape recorders, and search engines. The court observed that searching a cell phone could provide police with even more information about a person's life than a search of their home. The court acknowledged that the ruling might make it more difficult for police to do their job, but observed that, quote, privacy comes at a cost, end of quote. The opinion has been hailed as a landmark ruling by many commentators as evidencing the court's recognition that today's digital world may require the rethinking of various legal doctrines that were formulated in an earlier analog or paper-dominated era. Some commentators have opined that the Riley case inaugurates a new digital Fourth Amendment. Although the Riley case recognized a broad cloak of privacy for cell phones seized from an owner, it did not address access to cell phone records held by a third party, such as a cell phone provider. Based on a doctrine formulated in the 1979 decision in Smith v. Maryland, the current rule is that a person has no legitimate expectation of privacy in information voluntarily turned over to third parties. This third-party doctrine has been harshly criticized as being outmoded in today's digital world where vast amounts of personal information are routinely held by third parties, such as cloud providers, internet service providers, social media sites, online health providers, or cell phone carriers. A split has developed in the federal circuit courts and in several state Supreme Courts over the continued viability of the third-party doctrine. Ultimately, the Supreme Court will resolve the issue. In the meantime, several state legislatures have enacted laws that essentially override the third-party doctrine, at least for the purposes of state law enforcement officials. The continued viability of the third-party doctrine will be a central legal issue in the current constitutional challenges to the NSA's massive collection of telephone metadata from cell phone providers. Your readings for this week contain an article about the third-party doctrine. Read it carefully, as it is relevant to not only this week's discussions, but also to later class discussions about the NSA. Next week, we continue our discussion of the Surveillance Society, focusing on drones and the potential privacy threats they present.